Good afternoon, everybody. My name is Heather Edwards. I'm an attorney with Edwards, Stevens and Tucker, and thanks so much for joining us this afternoon for another after school special, our weekly webinar series in partnership with the El Dorado County SELPA. Today, we're going to be discussing student records and maintaining student records and how to navigate when we get a request for student records. I've done these presentations before. I could probably spend several hours talking about a lot of the nuances with student records, but we're going to try to hit some of the highlights for you today. As usual, as we end the presentation, we have an opportunity afterwards to stop the recording. We'll have some question and answers. So if you have any questions that you want to throw into the Q&A section as we go through the materials, please feel free to do that, and we'll make sure that we hit your questions as best we can before our time ends today. So let's get started. So to start off, the primary law that we are governed by in terms of privacy of student records is a federal law, the Family Education Rights and Privacy Act, which is a comprehensive federal statute that governs the privacy of student records. The purpose of FERPA, as it's known, is to ensure both parents and eligible students access to educational records and to ensure privacy of those educational records. And when we say eligible students, that means that all of the rights when a student turns 18 years old, or if they are enrolled in college, all of the rights transfer to that eligible student at that time in terms of their rights to have access to records and to provide consent to disclose records to third parties, those sorts of things. But up until that point, parents of students hold all of the rights as regard to access to student records. California law largely tracks the language of the federal law with some slight differences, but for the most part, it's pretty much in line. For example, there are some timing differences with the federal law and the state law in terms of how quickly we have to turn records around upon request. The California law is a much tighter timeline in terms of responding to requests for records from parents, and we'll talk about what those timelines are in just a few minutes. In terms of our students with disabilities, as we know, the Federal Individuals with Disabilities Education Act is the federal law that governs the provision of special education to students with disabilities. And IDEA does cross-reference FERPA in terms of that there is all of the students that are covered under IDEA are also protected under FERPA laws protecting privacy of student records. Specifically, IDEA talks about how it protects the confidentiality of personally identifiable information at the collection, storage, disclosure, and destruction stages of student records. IDEA also talks about how there must be a custodian of records that is identified for each local educational agency. And that would be the person, for example, if we get a subpoena for records, this custodian of records would be the one typically to sign a declaration saying, I am the custodian of records for XYZ charter school or XYZ school district, and I can certify that these are all the records that we have in our possession, those kinds of things. So you want to make sure that you do have somebody identified in that role at your LEA. And there's also language in IDEA that talks about how LEAs must maintain for public inspection a current listing of names and positions of LEAs who may have access to personally identifiable information. But for the most part, we really do rely on FERPA and state law when we're talking about student records and all of the rights governing student records. So in terms of parent rights, and again, when I say parent throughout the presentation, it could also be an eligible student. So a student who has turned 18 or are enrolled in college who would have those rights. But for the most part, we're talking about parents, and they have the right to inspect and review any educational records regarding their child only. So this is important whenever we're talking about records requests, that they're not entitled to see records related to other students. And so, for example, one of the things that we have to make sure whenever we're sharing records of a student with parents, that there aren't any other references to other students in those records. And we would need to make sure we go in and redact those references to other students before disclosing them to parents. Sometimes this could be in an incident report or a disciplinary record where schools may refer to other students by name. We would need to make sure that all of that information gets redacted from any records, because parents are only entitled to student records regarding their child. The other thing to be aware of in California is that in terms of who has the right to access records, even parents who don't have legal custody would have rights to access their child's educational records unless there's a court order stating otherwise. The difference in terms of custodial arrangements for a child is that only a parent with legal custody has a right to seek amendment of their child's educational records, and only parents who have legal custody are able to provide that written consent to disclose educational records to third parties. However, if you have a non-custodial parent and there isn't a court order that restricts their access to student records, even if they don't have legal custody to make decisions regarding a child, they may still have rights to access records regarding the child. And so that's an important distinction if there's ever a different sort of custodial arrangement with parents who may be divorced, that sort of thing, in terms of who actually has rights to access records. And then parents also have a right to file a complaint with the U.S. Department of Education and their Student Privacy Office if they believe that there's been an improper disclosure of their students' records, or if they weren't provided access to records, that sort of thing. Those are all potential areas that they could file a complaint with the Federal Department of Education or the California Department of Education when it comes to privacy of student records. So one of the first things to talk about when we're talking about educational records are, what are we talking about when we're talking about educational records? And this is always one of our challenges here in our office, is whenever we get a new case, a due process filing for a student with special needs. And then one of the first things that we oftentimes will do is we need all the records, right? All the records. And it's always interesting to me to see that, maybe the student has been in special education for 8 years and the amount of records that we get is quite small. And so usually it takes some work for us to work with our schools about understanding really what is an educational record. And the definition of an educational record, to which parents would be entitled to copies, to which we're going to want to make sure we have copies of, are any records that are directly related to an identified student and maintained by your LEA, or by a party acting for the LEA. And we'll talk about that in a minute. But the two main things to remember is that it's considered a record, an educational record, if it's directly related to student and maintained by the LEA. So educational records can be recorded in any manner. So it's not just those records that are written records. It also could be those records that are maintained on some sort of electronic database or audio recordings. And so this oftentimes will come up when we're talking about special education records that are maintained in our electronic systems like SACE or Welligent and other different types of electronic systems. It also comes up when we're talking about audio recordings of IEP meetings. So again, even if it's an audio recording that's on an old school tape recorder, or potentially a digital recording, or a CD, if people still have CDs around, those could all be considered educational records that the parent may be entitled to upon request. And the audio recordings of IEP meetings is definitely one that trips up schools from time to time, that they didn't think about that being an educational record that the parent would be entitled to. And that would mean even if the parents are also kept a copy for themselves. So for example, if a parent made an audio recording of an IEP meeting and the school did as well, the even if the parent had a recording for themselves, if the school has a recording and it's directly related to the student and maintained by your school, the parent would be entitled to a copy of that recording. So just keep that in mind. In terms of being directly related to a student, there isn't a statutory definition of what does it mean to be directly related to a student. Usually it's considered synonymous with what is considered personally identifiable information. So that's generally going to be considered things like a student's name, the name of the student's parents or other family member, a parent's or a student's address. If there's some sort of personal identifier, so if the student has a social security number or some sort of student number, a student identifier number, that would all be considered personally identifiable information. Other types of identifiers like the student's date of birth, the place of birth, mother's maiden name, and really any sort of information that if requested by a person who the educational agency or institution reasonably believes knows the identity of the student to whom the education record relates. A lot of times we'll get questions from folks like, well, what if we just use a student's initials and we don't actually use their names in any records? Would that still be considered an educational record? So first you have to decide whether or not it is an educational record, right? So is it directly related to a student and is it maintained by the educational agency? So if it is, then potentially it would still be an educational record that the parent would be entitled to. Let me go ahead here just for a second. There was some guidance on this from the U.S. Department of Education that said that records that identify a student by initials or nicknames or personal characteristics, you know, if you said, you know, that one student that we have in that one class, but you're not actually using their name. Basically what the guidance is that if based on that information, a reasonable person in the school community would be able to identify the student with reasonable certainty, that's still going to be considered directly related to a student. So in other words, if you use initials to identify a student, it's not going to necessarily mean that this is no longer going to be considered an educational record to which the parents would be entitled. The only reason why you might want to consider using students' initials or some sort of other identifier is it does protect the school, hopefully, in the event of some sort of inadvertent disclosure. And it could help you in terms of, you know, privacy concerns. So for example, if you're sending an email or something or some sort of document related to the student and you use the initials rather than their name and their birth date and all of that, it might be helpful if, you know, it didn't get sent to Heather Edwards, but it got sent to Heather, who is a journalist for the local newspaper. You know, you never know when you might accidentally send something to the wrong person via email. And so a lot of times if you are able to use initials and things like that, that might help protect the student in terms of improper disclosure of highly confidential information, but it wouldn't necessarily mean that it's no longer considered an educational record that the parent would be entitled to. So it doesn't necessarily help in that regard. The other factor in determining whether or not it actually is an educational record is it maintained by the educational agency? And not every record that directly relates to a student is going to satisfy that part of it, right? Being maintained by an educational agency. So there was a US Supreme Court case that talked about, generally speaking, educational records are those that are kept in one place with a single record of access. This case talked about when you're grading papers in a classroom and you're doing peer grading, and would that be considered an improper disclosure of an educational record? And the Supreme Court said no, because, you know, those records are not really considered maintained by an educational agency, and the purpose really is that it's supposed to be those records that are really maintained in a single place with a single record of access. The other piece of this is the designation of a document as an educational record depends on who maintains it, not necessarily who originates it. So as we said at the beginning, it could also be maintained by someone who's acting on behalf of your LEA. So for example, if you have contracts with non-public agencies or non-public schools for your students, at the very least, you would be obligated to inform parents that certain records must be retrieved directly from the non-public school or from the non-public agency in the event that those records solely reside with the NPA or the NPS. So if you don't have access to certain records, so for example, let's say the non-public school maybe has incident reports. If you don't have copies of those as your own LEA and you only have those at the non-public school, the cases talk about how you would at least need to inform the parents that they would need to reach out directly to the non-public agency or non-public school in order to get a copy of those records. There's also provisions within most master contracts with your non-public agencies and non-public schools that they should cooperate with the LEA whenever there is a records request. So oftentimes LEAs will just reach out to your contractors to get copies of any records whenever you do have a records request from a parent, and it just avoids the parent having to go directly to that contracted agency. The other factor that comes up a lot is this question about whether emails are considered student records. There have been several cases that have held that they are not considered to be maintained to the extent that the Supreme Court talked about educational records being maintained. So we have this district court case from Tulare that was one of the first cases that's been relied upon since then in OAH decisions, and a variety of other cases where a district court held that school district emails concerning personally identifying information of a student that hadn't been placed in the student's permanent file were not considered educational records under FERPA. Again, the court said that Congress contemplated that educational records be kept in one place with a single record of access to those records. And since emails had not been placed in the student's permanent file, they were not considered maintained by the school district and were not considered educational records. So therefore, the school district was not required to produce them under a request for student records under IDEA. So the court said here that being maintained by the school district suggests that the records would be kept in some sort of hard copy file at the school or on a permanent secure database. And it wouldn't include every email that the district receives or sends regarding a student. So what this generally means is that if you have emails regarding students, and oftentimes there's a lot of email communication that goes on regarding a student, trying to set up IEP meetings. You may have requests from parents for assessments. So generally speaking, those emails are not going to be considered educational records, even if they're requested by a parent, that parents would be entitled to, unless they're printed out and they're maintained in some sort of file or some sort of secure database. I would say we have to be very careful still with our emails, because within the context of litigation, emails can still be subpoenaed. They could still be the subject of a Public Records Act request. So we definitely still have to be very careful and very thoughtful about our emails, and they oftentimes become very important key pieces of evidence of maybe your efforts to try to schedule an IEP meeting, those kinds of things. And so they definitely are important in terms of being legally defensible, but generally speaking, they're not going to be required to be disclosed when a parent requests access to records. Generally, in terms of other types of records that are not considered to be maintained by an educational agency would be student work samples, assignments, things like that. Those are not generally considered maintained because they're kind of fleeting and they're always changing, that sort of thing. Other types of records, IEPs, are generally considered to be educational records. Due process hearing decisions, including any higher court decisions, if those were appealed to a higher court, would become part of a student's educational record, subject to the requirements and protections of FERPA. And CDE complaint reports are considered to be educational records that are subject to parental inspection, again, assuming that they identify the student by name or some sort of identifier. Assessment protocols are one that we get questions on frequently. So assessment protocols are those written instructions about how a test is supposed to be administered and the questions that are posed. Test protocols that include personally identifiable information are considered educational records within the meaning of IDEA and FERPA, and therefore parents have the right to inspect and review them. So if we have requests from parents for the protocols, there have been court cases that talk about that they do have the right to maintain, if they maintain them, if you have them. If you don't have the protocols, then there's nothing to turn over. But if you do maintain them, then they would have a right to provide them. There may be circumstances, remember, where an assessor needs to access those protocols other than the score sheet in order to adequately explain the student's responses on the score sheet. So generally, our recommendation is to maintain those protocols until the assessment results have been explained to the parents. So after an IEP meeting where you've talked about the results. And usually that information is necessary to explain those test results, which may be included in the reports that are drafted by the assessors. Typical practice would be to maintain those score sheets and shred the remaining test protocols, assuming that those other protocols don't have any information that's identifiable to a student. But again, remember that under FERPA, a parent can request an explanation of interpretation of a record. Typically, assessors who are familiar with testing instruments can explain the results using the score sheets by themselves without having those test protocols. But if not, you may want to consider keeping those for a little bit longer. There's also a case that came out of the Newport Mesa Unified School District back in the early 2000s that was really, well, isn't this some sort of a violation of copyright laws by providing parents a copy of these? And when the court weighed the various pros and cons in this situation, they indicated that providing parents of special education students with copies of test protocols constitutes a fair use exception to the federal copyright law. But they did talk about in this case that if there is concern about improper use of these, that there are certain safeguards that you could put in place in order to minimize the risk of improper use of those test protocols. And I have those listed here for you in the slides. There's also certain records that FERPA specifically has said are not considered educational records, and they have very specific exclusions to what would be considered educational records, even though they might include information that are directly related to a student and maintained by the educational agency. One example of one of the types of records that are not considered educational records are what are known as those records that are kept in the sole possession of the maker and are only used as a personal memory aid and are not accessible or shared with any other person except for some sort of a temporary substitute. So an example of this might be a counseling notes, right? So maybe during counseling sessions, your counselor is jotting down notes that are only used as a personal memory aid and are never shared with any other staff member. These are generally going to be considered sole possession records, right? Because they're just used to kind of help jog the counselor's memory about what was discussed. They're not shared with anybody else, so those would not be considered educational records to which the parent would be entitled. If, however, those counseling notes are shared with other counselors, or if you can think of other examples where there may be, information that's been shared. One thing that comes up, for example, are data sheets. So for example, if you are keeping data for a student on behavioral data, that sort of thing, if that information is shared with another person, oftentimes it may be a paraeducator who's sharing that information with a supervisor. that now is no longer just a personal memory aid. It's actually those data collection sheets may be something that are going to be considered educational records because they weren't kept in the sole possession of the person who made the record, if that makes sense. The other thing to be aware of is that there are 3 categories of records in terms of the types of records that you must maintain and for how long must the school maintain those records. This is found in the California Code of Regulations. And there's 3 categories of records. The first are mandatory permanent records, and those must be kept forever in perpetuity, or some sort of copy must be kept forever. And we'll talk about what is included in those permanent records. Mandatory interim records, which need to be maintained for a certain period of time and then may be destroyed after a certain period of time. And then we have permitted records, which are those records having clear importance only to the current educational process of the student. So these are a listing of the mandatory permanent pupil records that every LEA must keep forever regarding a student. We're talking about the name, the date of birth, method of verification for the birth certificate that you've used, when they entered the school, when they left, transcript type of information. So this type of information must be kept somewhere, somehow, forever for a student that's been enrolled in your LEA. Mandatory interim pupil records are typically where most special education records fall. So these records would be health information, participation in special education programs, including assessments that have been taken, progress notes, any sort of parent authorizations or prohibitions on so if the parent has opted out for certain types of participation in statewide testing, for example, those sorts of things must be maintained. And results of standardized tests that were administered within the last 3 years must be kept on an interim basis. And only when those have been determined to no longer be necessary could they be destroyed. So typically most LEAs have policies and procedures for the destruction of educational records and when that should occur. And then permitted pupil records are standardized test results, for example, that are older than 3 years. Routine discipline records, all disciplinary notices, attendance records, those sorts of things. Those are considered in that 3rd category that don't have to be kept forever and ever, or even on an interim basis. So really important to familiarize yourself with these different categories of records and what your policies say in terms of these types of records. So in terms of our timelines when a parent has requested their ability to access a student's records, what the law says is that parents are entitled to copies of records or that they may come and inspect and review records excuse me, during regular school hours. So in California, parents are entitled to access records within 5 business days of the parent's request. Sorry. And this means a couple of things. Parents do not have to put their request for records in writing. So even if you get a verbal request for records, that would still trigger that timeline for us to respond to the records within 5 business days. You could certainly ask for the parent to put the request in writing, but they're not required to do so, and you still would have an obligation to maintain or to access those records, provide those records within 5 business days. And it's also really important that a lot of places throughout IDEA and the education code, we use different terminologies for calendar days, school days, business days. And in this situation, we're talking about 5 business days, which is not calendar days and it's not school days. So this generally means the days of the week other than, not including the weekends, not including state and federal holidays. So this typically means if you get a request for records over summer break, even if your school offices have been closed down for the summer, there is still this timeline that parents would be entitled to records within 5 business days. So really important for you to kind of think through during winter break and summer break, if you get one of these requests that come in, how are we going to access those records and be able to respond within 5 business days? And so just a good idea to be aware of how quick that timeline is in order to provide those to a parent. And a lot of times, like I said in the beginning, you're really trying to figure out where are all the records. Sometimes the records are maintained in a cumulative file, but there also may be a special ed file that the case manager has. Again, anything that's directly related and maintained by the educational agency, they would be entitled to, regardless of where you keep it in your school. So it's really important to make sure that we're getting all those records and we're providing them within a timely manner. For special education students, the LEA must comply to a request for school records without unnecessary delay before an IEP team meeting or any due process hearing, but in no case more than 5 business days. And so this is really important. If you have an IEP meeting coming up and a parent has made a request for records, we do have to try our best to get them those records prior to the IEP meeting, but again, in no case more than 5 business days. Also under FERPA, the right to review and inspect educational records is personal in the sense that the district is not required to allow a parent to assign or delegate the right to review to some sort of representative, regardless of whether that person is an attorney or an advocate or something else. But for special education students, IDEA specifically grants a designated representative the right to inspect a student's records on behalf of the student's parents. So we would want to make sure we have a signed release from that representative before turning over the student's records. Most student attorneys know that that's the case, and they will have written authorization signed from the parent that they will send along whenever an attorney's office is requesting records. But if not, we can certainly request that from the parent, because we want to make sure that this attorney actually is the parent's designated representative and the parent has granted them access to those records. In terms of charging for copies of records, LEAs are allowed to charge no more than the actual cost of duplicating those records. You can't charge parents for whatever it costs in terms of administrative time to go find the records and gather them, that sort of thing, but the actual cost of the copies. For example, 10 cents a copy is kind of a typical going rate for charging for copies. However, if the charge effectively prevents the parent from exercising their right to receive copies, if it's some sort of financial hardship, then we can't charge a record. We can't charge a fee for copying those records. So oftentimes when we get requests for records from a parent or a parent's legal counsel, generally they will ask to waive the copying fee because they'll assert that it prevents them from exercising their right to receive copies. And so we would just make sure we provide them copies. There is no obligation to mail records to a parent. It's perfectly acceptable to have records available to be picked up at the school office. Oftentimes electronic records, as long as they're being sent in a secure manner, are very appropriate, and most law firms actually would prefer to have them electronically. There's no requirement to do it electronically. If you want to provide the records hard copy, that's okay. But oftentimes electronic records seem to be the way that most people are transferring records upon request. A few tips for responding to a request for records. First, you want to call the parents, let them know you've received the request, and let them know that how they're going to be able to get the records, that you'll send them through a Google Drive, or they'll be on Dropbox, or that they can pick up the records at the district office or at the front school office, that sort of thing. So you want to make sure you acknowledge that you've received their request. You could send an email, that sort of thing. You'll want to make sure you ask the school to bring the site files, the teacher files, if there is one, to the district office and compare it with the district file to really make sure all documents are included. Oftentimes we will see that maybe one set of files, for example, has the signatures, but another set of files does not. And so we really want to make sure that we've got a comprehensive set of all of the records that are directly related and maintained by the educational agency that we can provide in response. Have someone who's knowledgeable about the rules and about the file to review the file and maybe go through and review any duplicates or things that shouldn't be included in the file. Believe it or not, oftentimes we've seen records get submitted that actually include records of another student. So we really want to go through and make sure that they're only getting the records that they're entitled to and that there aren't things that are really obvious that are missing. As we already talked about, we'd want to go through and redact any names of other students that might be included in there. The things that I see most often that people forget to include, oftentimes when we get a request for special ed records, or for records for a special education student, we typically will include IEPs and assessment reports and that sort of thing. But we don't want to forget about attendance records and disciplinary records and behavioral logs, any sort of report cards, progress reports, the signed assessment plan. Those are the kinds of things that we want to make sure are included in that, so that we don't have an additional complaint where the parent might argue that they were not being able to meaningfully participate because they didn't have all the records that they were entitled to. Really make sure you prepare those documents for the parents. Don't just blindly copy everything that the school brings you and give it to the parents, because again, we want to make sure that we're very thoughtful about what is included in there. The other thing to be aware of is that a request for records is usually a signal that something is maybe not going well. Maybe the parents are unhappy and they're getting ready to go to a lawyer if they haven't already. So usually it's kind of a good time to ask staff, like, hey, what's going on with this case? We just got this request for records. Maybe, the case manager can figure out like what the parents want or what they're upset about. It's a good opportunity to review the documents. Does anything jump out at you as, wow, going through these documents, I realized that we missed a triennial date and we need to jump on that right away. Maybe it's an opportunity for you to schedule an IEP meeting to see if you can come together and address any issues or concerns that the parent might be having at that time. So it's usually a good signal that more is coming, and there may be a problem. And so it's often a good opportunity for you to really review the case. So in terms of parental consent for disclosure to third parties, FERPA precludes LEAs from disclosing personally identifiable information from a student's educational record without first obtaining signed and dated written parental consent, subject to a whole bunch of exceptions. So we want to make sure that we've got parental consent from a parent that's signed and dated before we actually disclose those records to a third party. That written consent needs to be very specific about what records are authorized to be disclosed, what's the purpose of disclosing the records, and who is entitled to receive those records. If the parent or the 18-year-old student requests the records, then you just would provide a copy of those records that you have disclosed. So there are a number of exceptions, as I mentioned, to that prior written consent rule. There's a number of times when an LEA may disclose educational records without prior written consent from a parent. So the ones that we typically see that when we're talking about students with disabilities are requests for directory information. And so that's the kind of information that you would typically see in a yearbook or on a program of a drama performance, students' names, that sort of thing. Typically that's going to be considered directory information, but parents also have the right to opt out of allowing their child's directory information to be disclosed without parental consent. So definitely something just to be aware of. If there's a health or safety emergency, we may be entitled to disclose information regarding a student without parental consent. We'll talk about this in a second. Disclosure to school officials with a legitimate educational interest, disclosure to other schools, and we'll talk about that as well in terms of transferring records, disclosure to governmental agencies for certain purposes. So for example, when we get a complaint from the California Department of Education or notification from CDE that a parent has filed a complaint, they may ask for certain records that will aid them in investigating that complaint. And so this is the law that allows us to disclose those records as a governmental agency who is charged with investigating these sort of complaints. There are certain records that may be disclosed to agencies like law enforcement or juvenile justice types of folks, or even social services agencies under certain circumstances. So again, definitely want to check with your legal counsel if you get requests for records, for example, from the district attorney's office or a public defender or those kinds of things, because there are only certain circumstances that we can disclose those records. And then court orders or subpoenas. So if we get court orders or a lawfully issued subpoena, that we may be required to disclose educational records in response to those court orders or subpoenas. And we would want to make sure that we're following all the rules for those. Generally speaking, when we get a subpoena for student records, we would want to make sure that we follow our obligation to notify the parent that we have received a subpoena and that we intend to comply with a subpoena for educational records. And that gives them an opportunity to try to stop the court from allowing us to send those records as appropriate. So the issue with school officials with a legitimate educational interest. So this really comes about in terms of who within your educational entity has a legitimate educational interest to certain records. And that's really within your discretion. So you get to determine who has a legitimate educational interest in certain types of educational records. So usually your annual FERPA notice that gets sent to parents includes what your definition of who is considered a school official and what constitutes a legitimate educational interest. So for example, it may not be appropriate that the school secretary or a custodian has access to a student's psychoeducational report, right? They may not be a school official with a legitimate educational interest, but there may be others in terms of teachers or administrators or even board members who may have a legitimate educational interest in certain types of records. And so you want to really be familiar with your policies about who has that authority and who can review a student's educational records or have access to them within your organization. Really want to make sure you review the records only in order to fulfill their professional responsibilities or to fulfill the school's mission. It's really on a need to know basis, not just for curiosity's sake. And that's how we maintain confidentiality even within the organization. We do have to make sure that we are keeping an access log. So you have to keep a log of every request for access to and disclosure of records for each student, as well as the names of state and local educational authorities and federal officials that may make further disclosures of personally identifiable information without consent. So you have a log usually of who's requested and received records, and that way we maintain that access log and the parent would be entitled to a copy of that access log of who's actually accessing the student's records. In terms of transferring educational records for our special education students, when a student has transferred to a new LEA, the rules are that the new school agency must take reasonable steps to promptly obtain pupil records, including IEP and other documents relating to the student's special education and related services. The previous school must take reasonable steps to promptly respond to the request from the new school, and the former educational agency is required to send the pupil special education records or a copy within 5 working days upon request from the new school. So we hear oftentimes about these situations where maybe the former LEA, we've asked them and they haven't sent us any records, and it's making it very difficult for us to be able to move forward with an IEP or figuring out what the student needs. I oftentimes like to send a letter to those former LEAs, reminding them of what the rules say and what the law says in terms of their obligation to provide us a copy of that information within 5 working days, because it really can hinder our ability to move forward for making sure we're implementing the student's program right away. Don't assume your obligation to maintain a student's special education records is concluded once you forward records to the new LEA. So, oftentimes maybe a student has left your school district or they've left your charter school, you send the records on to the next educational agency and we're done. However, remember that we really do need LEAs to keep records for a certain period of time in order to be able to show compliance. So remember that the statute of limitations for filing due process is 2 years from the date that a party knew or had reason to know of the facts underlying the basis of that request. So you could get a due process complaint today regarding a student who is alleging a denial of FAPE back in February of 2021. And we would need to have some records to be able to defend ourselves about whether or not the student was receiving FAPE over the last 2 years. Or maybe they file a compliance complaint or some sort of civil rights complaint with the Office for Civil Rights. So really, best practice is to keep a copy of a student's special education records a minimum of 3 years after the student has left your LEA, so that you are able to defend yourself in a situation where you may have a filing after the student has left. There is some way for us to get those records back if we needed to from the next LEA. I've had this come up for me on occasion, that what the definition of disclosure under FERPA is to permit access or the release, transfer, or other communication of personally identifiable information contained in the educational record to any party except the party identified as the party that has provided or created the record. So what this means is, let's say that we sent across to another LEA all the students' records and we didn't maintain a copy for ourselves. And then we get a due process complaint and we say to that next LEA, oh shoot, we didn't keep any copies of the students' records and we just got a due process complaint. Can you send us all of the students' records back, like send them backwards to us because we didn't keep a copy? And what the law says is that you may provide a student's records, only those records that they created. So they could only send back to us those records that we had sent to them, if that makes sense. They would not be able to send us any new records that they have created. So if they've held IEP meetings or done assessments for the students since we had sent them the records, we would not be entitled to any of those. That is because of this specific definition of what is considered a disclosure. And the Federal Department of Education has indicated you can send records backwards, but only those records that you had sent on to them, if that makes sense. Okay. And that's all I have for you today. Here is a link to our free legal alerts if you're interested in signing up for those. And then we'll go ahead and we will stop the recording.